The tale of the adjudicator who cared too much for his fees. Once upon a time, there was an adjudicator who cared too much for his fees. When he accepted his appointment as adjudicator, he immediately instructed for his fees to be deposited. This is, of course, a common practice. However, when the deposit was not forthcoming, he then issued a direction to say that the respondent will be barred from submitting an adjudication response for failing to pay the deposit. The respondent, in abundance of caution, nevertheless filed a bare response. They made it clear that it was bare by reason of the adjudicator's directions. The claimant, of course, realizes the grave error of the adjudicator and stresses that they have no objection to the respondent filing an adjudication response. But alas, as is commonly the case, once an adjudicator or arbitrator has made a clearly erroneous ruling, they rarely depart from it. The respondent also formally applied to be afforded the opportunity to file a proper response. Without deciding on the application, the adjudicator issued his decision. No prizes to guess how his decision went. The High Court looked at these facts and observed that the claimant in adjudication must necessarily be the party to pay all adjudicator fees and expenses in the event a respondent refuses to do so. An adjudicator cannot simply bar a respondent from participating in the proceedings. In fact, an adjudicator must proceed with the proceedings regardless whether the deposit is paid or otherwise. An adjudicator's right to his fees is preserved by withholding the decision after completing the adjudication process until his fees are paid. Therefore, the adjudication decision was duly set aside. Sounds fictional? Not at all. This was the case of Fortune Facade Treatment SBV Peng Tiong Ji. At Kang Ho and Lee Yuan, we handle construction disputes, period.